Assalamualaikum warahmatullahi wabarakatuh. Hello everyone, my name is Rezky Aprilia with student number B1A1236163 and I'm a student of the International Class Faculty of Law, Universitas Jambi batch 2023 and my partner.
Hello, my name is Saharani with student number B1A12361 and I'm from the International Class batch 2023 majoring in Law, Faculty of Law from Universitas Jambi.
Today we'll discuss a fundamental topic in our labor law course, which is under the guidance of Dr. Arrie Budhiartie, M.Hum.
So in this video, we will be covering basics of labor law. We will explore the definition of labor law, the subjects and objects, the goals and principles behind it, its nature, sources, and a brief history. This topic forms the foundation of understanding how labor law governs the relationship between employers and employees, ensuring justice and fairness in the workplace. And the first one, I will be explaining about definition of labor law. Labor law refers to the body of rules that governs the relationship between workers and employers, encompassing rights, obligations, working conditions, labor protection, and dispute of resolution. In the context of Indonesia, labor law aims to create a fair, healthy, and safe working relationship for employees while also supporting employers in managing their workforce efficiently. And the next one is subjects of labor law. The subjects of labor law consists of two main parties. The first one is workers, the individuals who work based on employment contract to receive wages, and the second one is employers, parties that hire workers to run a business or enterprise and are responsible for managing working conditions and the rights of workers. In the next one, I will be explaining about objects of labor law. The object of labor law pertains to everything related to employment relationship itself. This includes the protection of workers' rights, regulation of wages and salaries, working hours, social security, working conditions, and dispute resolution mechanisms between workers and employers. Its primary goal is to ensure a fair balance of rights and obligations for both parties. Objectives of labor law. The main objectives of labor law are: the first one is protection of workers' rights, ensuring workers receive fair compensation, safe working conditions, health benefits, and protection from exploitative practices. And the second one is creating harmonious employment relationships, ensuring clear agreements between workers and employers, and providing fair mechanisms for dispute resolution. And the third one, or the last one, is guaranteeing social welfare, that is providing social protection programs and welfare benefits for workers.
The principles of labor law in Indonesia ensure fairness and protection for workers while supporting economic development. The principle of justice promotes balance in the rights and duties of employers and employees, while the principle of equality and non-discrimination ensures fair treatment regardless of gender, race, and religion. The principle of protection safeguards worker rights, ensuring fair wages and safe working conditions, while the principle of freedom to organize supports unionization and collective bargaining. The principle of work-life balance emphasizes reasonable working hours and well-being, and the principle of human dignity ensures respect for workers' rights and freedoms. The principle of economic development balances business growth with workers' welfare, and the principle of legal certainty ensures clear, consistent, and enforceable labor laws. These principles collectively establish a fair and supportive framework for employment in Indonesia. Labor law in Indonesia is specific as it regulates detailed worker-employer relationships. Protective because it ensures workers' rights and safety. Adaptive since it evolves with workforce changes. And comprehensive as it covers diverse employment issues to maintain fairness and balance. The sources of labor law in Indonesia include Law No. 13 of 2003 on manpower, which governs employment relationships, workers' rights, and employers' duties. Additionally, Law Number 2 of 2004 on Industrial Relations Dispute Settlement provides mechanisms for resolving employment conflicts, while Law Number 21 of 2000 on Labor Unions regulates union formation and activities. These laws are supported by government regulations, ministerial decrees, and collective labor agreements, ensuring fair and balanced employment practices in the country. Labor law in Indonesia traces its roots to the colonial era when the Dutch implemented regulations to manage the workforce. After Indonesia's independence in 1945, the government began to develop its own labor law to protect workers from exploitation and improve working conditions. Over the years, these laws have been revisited and updated to address industrialization, the rise of labor unions, and the need for better social security. Today, Indonesia's labor law continues to evolve to meet the demand of a modern workforce, focusing on the protection of workers' rights and fair employment practices. In conclusion, labor law in Indonesia plays a critical role in ensuring fair and harmonious relationships between workers and employers. Through its principles and legal sources, it guarantees the protection of workers' rights and establishes a balanced framework for both parties. As the labor market continues to evolve, labor law will also adapt to address new challenges and maintain social welfare. The ultimate goal is to create a fair and just working environment for all. I think that's all from our presentation. Thank you so much for your attention. We really appreciate it. The last we say, wassalamualaikum warahmatullahi wabarakatuh.